Hello, I'm Don Blythe. I'm a San Francisco divorce financial mediator, a certified public accountant, and a certified divorce financial analyst. And with me today is Lisa Murray. Lisa is a family divorce attorney in San Francisco. Lisa, tell us a little bit about yourself and what you're going to talk about today.
So I got my license to practice law in 1987 and started practicing family law in 1989. I'm licensed to practice in both California and Hawaii. And I've been litigating since 1989 through the beginning of 2018, at which point I stopped taking on new litigation cases and have concentrated my practice on consensual dispute resolution, which is mediation, which I've been practicing since the late 1990s, and collaborative practice or collaborative divorce, which I have been practicing since the early 2000s, about 2003.
And our topic today will be community property and separate property and what that might mean. Is that right?
That's right.
Okay. Well, let me start then. What might be, since you're an attorney, what might be the legal definition of community property?
So the legal definition of community property is that anything acquired during marriage, and that means after your actual date of marriage and before separation, is presumed to be community property. That can be rebutted or refuted by a person or a spouse who claiming that property in fact isn't community, but should belong to them as separate property.
And how about separate property then? How would you define that?
So separate property is anything that you bring to the marriage, so anything you acquired before marriage and then still own after you get married. Anything that you acquire during marriage by way of a gift or inheritance. Additionally, if you did bring some property to the marriage, or if you inherited property during the marriage or was gifted property during the marriage, then any rents or increase in profits or anything like that acquired during the marriage also remains separate property.
It's my understanding that there's two other kinds of property called quasi or mixed property. What does that mean?
So I'll start in reverse order from your question, Don. Community property is property that, as California residents, you might own, but it's actually located outside of the state of California. So it might be a house in Arizona. That property is treated in California as community property, even though Arizona may not be a community property state. And therefore, what we call it is quasi or quasi community property. Property is something that you brought to the marriage, started as community, it started as separate property, and then during the marriage, the community starts to gain an interest. A good example of that might be a 401k or a pension plan, where the employer before you married, and you had a value in those accounts or vested time, and then you continued to work for that company after you married, and you again continued to either make contributions or your employer made contributions on your behalf. And now the community starts to gain an interest in that account because anything acquired during marriage is presumed to be community property. And so that then becomes a mixed asset or mixed property.
So when a couple gets married, everything doesn't become 50-50.
No, things that you brought to the marriage remain your separate property. Things that you acquire during marriage are community property, and it may become a mixed asset. But just because you marry doesn't mean that everything you owned before is now suddenly 50% owned by your spouse.
So if you bring something into a marriage and then it increases in value during the marriage, what's that increase?
So if that increase is just purely an increase, say, due to market forces or the stock market, then that remains separate property. It can get a little complicated if the increase in value had to do with your efforts or skill in managing that asset. Then your spouse might be able to claim that the community really has an interest in that, even though you owned it before you married, because again, during marriage, your actual time and efforts belong to the community. So if you're managing your investment portfolio or continuing to run your business, the community might start to gain an interest.
So does that mean if one spouse has a retirement plan they've contributed to during the marriage, that since that comes from their effort, that is all theirs, or would that be divided somehow?
No, efforts belong to the community after you're married and before you're married. So if you go to work every day and your employer contributes to the retirement plan and you contribute to your retirement plan, then those contributions and gains or increases in value of those are community property. So then you would have the perhaps classic mixed asset, an account or an asset that has some community interest in it, as well as some separate interests in it.
Okay. If two independent people get married and they each have separate bank accounts and they keep those separate bank accounts and their names are on each bank account, but they don't share, what does that look like as far as who gets what?
So again, we look at the source of the asset or of the income or of the money, if you will. So if the source of the funds going into this bank account that you owned before marriage and is continued in your name, those are still community assets. That's still community money. So your bank account will then become a mixed asset. And you may agree that you'll keep the bank account in your name and your spouse will keep the bank account in their name. But that's a gentle person's agreement, or you can turn it into a written agreement. And the community value in those accounts, whatever it may be, will remain community and will have to be accounted for in some way or equalized in the overall division of property.
Okay.
Sometimes, if you have that bank account and you brought it to the marriage and had a value or had a balance of, say, $10,000 at the date of marriage, and then you put in money and then you withdraw money and you put in money and you withdraw money after marriage, the account may become so mixed up that it's impossible to tell whether the money you brought to the marriage, your separate property money, even exists anymore. And so it may become all community property, unfortunately.
Is that what they refer to as commingling?
Yes, commingling. And sometimes it's, what we call hopelessly commingled. It's so mixed up that it's impossible to tell what's community and what's separate. And then the default in a divorcing situation or a legal separation situation is if there were funds deposited into that account during marriage, then it's going to be presumed to be community property. And the person who is asserting a separate property interest in that account can bring in documents or other evidence to rebut that or refute that claim. And then it's a matter of sort of figuring out, throwing the evidence on the scale, throwing the statements on the scale, and figuring out whether or not there's any separate property left or any community property left. But there's a strong presumption that property acquired during marriage, regardless of where it's deposited or held, or in whose name it's held, is community property.
Even in litigation, is it possible for a couple to agree to allocate their separate accounts to each other as separate property, or does the law override their agreement in that regard?
No, spouses are free to agree to divide their property in any way that seems appropriate to them. Generally speaking, regardless of which process, divorcing process or legal separation process you choose, if you and your spouse are able to reach an agreement, then a court will go along with that. The judge will likely sign off on that agreement as he or she is signing your judgment.
Okay. How about inheritance? Is that always separate property, or can that somehow be mixed or divided?
Well, again, I'm feeling a little bit like a broken record, but these are the tenets or the foundation of community versus separate property law is provided that when you get that gift or inheritance, you treat it properly and you don't mix it up, hopelessly commingle it with your community money, then it will remain your separate property. If you, for instance, if you inherit your mother and father's home, and then you put your spouse's name on it, there's going to be a presumption that you then changed the nature of that asset from community or from separate property to community property through a process that we call transmutation. It's called a transmutation of property. Now, there are certain legal considerations that go along with that, meaning the spouse who is quote unquote transmuting that property, aware of what they're doing, and the law says there needs to be a writing that basically says, I know that I am changing the property from my separate property inheritance into my community property or into community property. And so there's some acknowledgement that happens. And where this comes into play sometimes is during the loan refinance process, and you'll go to the title company to sign off on the refinance documents, and the title officer will suggest to you that you put it in both of your names, or your mortgage lender will say you can get a much better rate on your interest if you put it in both of your names. Then there can be a question again that what can you do to rebut or overcome the presumption that was not a real transmutation. It was simply a convenience. It was a convenience to save some money or get a better loan or something like that.
Okay. Let's talk about debt. If one spouse brings debt into the marriage and it's paid off during the marriage, how does that work?
So generally, if you're paying off consumer debt, so credit card debt, car loans, that kind of thing, generally if community property is used to pay separate debt, just thank you very much, community, that was very helpful type gift. There is some exception based upon how long your marriage was. If it was a shorter duration marriage, then it's possible that you might need to reimburse the community for the separate debt that was paid, but it's a short window of time. Student loans are sometimes treated differently. If you pay off student loans, you might have the ability to recoup that. And again, that's going to depend upon the length of your marriage.
What if during the marriage, one of the spouses goes to school and gets a rather large student loan and never really practices? Does the community have to benefit from that loan for that to be community, or how's that work?
So generally speaking, student loans belong to the student, even if you're married, because the student is the one that's getting the benefit of the education. Now, if you get married while you were in graduate school and you took out some loans to go beyond that or to pay for the second part of it during marriage, and now you've got these student loans and it's still outstanding at the time that you separate and are getting a divorce, the general law is that those student loans belong to you unless you've been married for 10 years. So that's a rule of thumb. It's not going to be an exact, but you've been married for a period of time such that the community is considered to have benefited from that education. The community, your earnings are higher than they would otherwise have been by virtue of that education, and therefore the community is considered to have been made whole. And so then those remaining debts could be a community debt.
We're in the Bay Area, so a lot of folks get stock options. Let's talk about those. How do those work?
So stock options are treated similarly to retirement plans, if you will. The general stock option model is you get a grant today, and then you've got to continue to work for the company for a period of time, most often 4 years, for you to actually vest or for those stock options to actually become yours. And so, again, your efforts belong to the community. So when you wake up in the morning after you married, the things that you do now belong to the community. And so to the extent you're going to work and that work time is working to accrue the vesting of those stock options, then those stock options become. Now, grant was given, say, the month before you married. You got a nice big grant Facebook stock option.
Okay.
Then you marry and you continue to go to work. Then there may be a small separate property interest in that asset because you worked for a month of vesting time during before you married. So that's separate property. And the same on the back end, right? Which is if you get a stock option shortly before you separate, but the vesting time continues after your date of separation, then those stock options again will become mixed, and there'll be a community property component and a separate property component.
Would that apply to also restricted stock units?
Yes, restricted stock units, executive compensation plans, etc. Right.
How about if it's a startup that we're talking about? How does that look?
Well, startups can be a little complicated because there isn't really a market for that stock. Generally, they're privately held companies and they often have no value, at least for a little while. So there's no market to liquidate them. So generally speaking, the community versus separate property analysis is the same. The question becomes, how does the non-employee spouse get their interest, right? They may be impossible to value, or there's no way to do a trade, right? You keep your stock options and I'll keep some cash, or I'll keep another stock account that's not tied up with your employer. And in that instance, we fashion an agreement that says that your soon-to-be ex-spouse will hold your share of those stock options in what we call constructive trust. And if at some point they're either able to be exercised and sold, or there's an initial public offering and you're able to get some value for them, then you'll get your share. Now, depending upon how long is left on the vesting schedule after you separate, your interest in those stock options may be getting smaller and smaller with each month or quarter that goes by.
Okay, let's talk about debt. If one spouse has a spending difficulty, the other spouse going to be responsible for that, and how's that looked at by the court?
Well, generally speaking, anything acquired during marriage is community property. That includes assets and debts. So if your spouse likes to shop at Nordstrom's or perhaps on QVC or Amazon, that's debt, and it's presumed to be an equal obligation of both spouses or an obligation of the community. There can be some exceptions. If there's a gambling problem, right? And someone's going up to Las Vegas every month and they're gambling things away, and you really didn't know they were on a business trip and you didn't know they were going into debt to gamble, you might be able to, again, rebut the fact that that's a community obligation, because you could claim or try to claim that the work efforts of your spouse in accruing that debt really wasn't benefiting the community. It was in fact harming the community by making the community go into debt. But that's a bit of it's a bit of an uphill battle. The general rule is going to be that through marriage, the community is responsible for the debt, generally speaking.
Okay, how about a business? Let's say a husband has a business, they get married, wife helps, wife contributes, or wife helps grow the business, but it's all in his name, and she really can't run it or doesn't want to run it. How does that get apportioned?
So similarly to any mixed asset, it may become a mixed asset. We try to track what was the value of that business on the date of marriage, and what happened to that business during marriage, and why did it, say, grow or become more profitable or larger. And so we generally bring in either business valuation specialists, or if you're in the litigation world, forensic accountants, and we try to determine how much of this growth is attributed to things that happened during the marriage versus the owner spouse had really set themselves up for this growth to happen before marriage, and therefore they're just reaping the benefits or the gains and rents, if you will, of their separate property asset. And there's a couple of methodologies that can be used to do that, which are probably a little complicated to get into for this presentation.
Talk to me about wedding rings. What's their status?
So wedding rings are given to a spouse technically before they marry, because you exchange your rings before the officiant says, "I now pronounce you man and wife." And so those are a gift that was given before marriage, and those are the separate property of the person that receives it.
So let's say husband didn't have any money at marriage, but then a year later, after they're married, he goes out and buys a very expensive wedding ring and gives to his wife. Does that change the complexion?
Depends upon how expensive that ring is. To the extent that he goes out and replaces the ring that he bought with a bigger ring and gives it to his spouse, then hopefully that is a gift. And remember that property acquired during marriage by way of gift or inheritance is separate property. So that would be the separate property of the spouse who received it. Now, there's a case out there that does provide for an exception, which is if the value of that ring is so extraordinarily higher than any pattern of gifting or gift giving you've had with one another over the course of your marriage, then the court might find that it really wasn't a gift. It was really more of an investment that you were making. Instead of putting it in the stock market or a mutual fund, you put it in a big diamond ring. There's a possibility the court could find that it was not a gift and that it was investment. But that is the exception and not the rule, for sure.
Thank you. Let me ask, how about mediation, collaboration, and do-it-yourself divorce? How might your comments change in those circumstances?
Well, in the litigation context, generally speaking, some lawyers get very nervous about allowing their client to reach agreements that are too far afield of what a judge might do. And a judge is bound by the law. The judge can interpret facts, so the facts of your case, but the only thing they can do is apply the law to it and come up with a conclusion about how the law applies in your particular circumstance. Divorce, neither you nor your spouse is bound by the law. You can choose to follow it if it makes sense for you, but you choose to do something different, do something that works for you. And I'm common examples of that where and they, use that money to, pay down some community property debt or to send their children to a private school. I've had cases in which couples have acknowledged that that was separate property money that was used to benefit the family or the children, and therefore they'll say out of the house sale proceeds, why don't you take your $25,000 back, because I know that was your aunt's money and we spent it, but really you should have your aunt's inheritance. And so I've had lots of couples do that.
Thank you, Lisa. Thank you very much.